back on the record, this is the beginning of tape number 11 of the due process hearing in the Crossett versus Jordan School District matter. The time is 10:37.
And just to take us back to before the break, we were talking about the procedural safeguards and when Mr. Crossett first received the procedural safeguards, which were apparently attached to a letter from Mr. Evans around the 17th of October.
And I would just like to hear this witness say that she never gave me those procedural safeguards before the evaluation meeting, during them, or after. And she's the director of special education and gives training on that to the rest of the largest school district in the state of Utah.
And I'm going to object on the grounds that it has been asked and answered.
Actually, it is slightly different, and I have the same question. I mean, the other questions were slightly narrower. When was the first time anybody in Jordan School District gave Mr. Crossett procedural safeguards?
October the 17th.
Okay, that's...
And Mr. Evans seems to have no information of when the meeting was held. Do you remember when the meeting was held?
October 1st.
So how many days was it from the meeting until I received the procedural safeguards?
Apparently 16.
16 days. Is that a violation of the policy and procedures of Jordan School District?
It would be if there were not reasons that you were not given them sooner.
Mm-hmm. Seemed to be some question on this executive order. Again, counsel, where my thumb is, I'm going to have her read that section of the...
Can you just give me the citation?
Yes, Department of Justice, Federal Register, Volume 66, number 12, Thursday, January 18, 2001.
Wait,
So-
that is different than this one.
Yeah, this, if you continue on, the first part is the actual executive order, and then roughly a third of the way through that, we have
Oh,
the
I see,
attached.
I see, I see, okay.
And so what page of that are we looking at, Mr. Crossett?
5398, please.
There's page numbers.
Top left.
Top left.
Okay.
Isn't this document basically that you're looking at is a further explanation of how that executive order is to be enforced in the United States, including the state of Utah?
I haven't read it. That is generally what regulations are for.
Okay. Could you start where my thumb is right there and read to the court? The executive order is...
Toward that end, the executive
Wait.
order,
Hang on, can you give us a reference for the rest of us, please?
it is in the middle, about the middle of the summary paragraph on 5398.
There's 3 columns on my page.
First column.
First column,
Middle of the first
okay,
paragraph.
I see it, thank you.
Toward that end, the executive order is intended to supplement existing laws and regulations that already prohibit many forms of discrimination in both federally conducted and federally assisted educational programs.
So the federal government basically put out a manual for states and others expanding and further explaining how that executive order is to be implemented in the United States. Is that correct?
Your Honor, I have the same objection that I have had all along, and I fail to see the relevance of this document. It's a legal conclusion as to whether it applies to Jordan School District.
Well, go ahead, if you have a response.
Yes, Your Honor. One of the main things that is on the board is the executive order that says that I am a legal parent in the process of adopting, and anyone that gets federal monies has to abide by the federal definition of a parent, not the Utah regulations. They're moot. I think it's important that not only is the executive, I have a responsibility to the preponderance of the evidence, and I've read the decisions by this court, and it appears that it has to be very specific. The executive order, under most circumstances, would speak for itself. But now here is a more expanded federal document that indicates what they really mean by that executive order, enforcement.
The objection is sustained because I understand that you want to get this document in, and I'm sure that Ms. Andrews has views on whether you have correctly summarized its applicability and whether it in fact augments, supersedes, conflicts with IDEA. But that's a legal issue that we'll deal with at the end of the hearing. If you want to draw our attention to particular parts of this, that's
Okay,
fine.
judicial
but-
notice then, please.
Well, and that's fine, but I don't want you just, it's not appropriate to just ask this witness to sort of respond to your assertion about the meaning of parts of the language. So to that extent, the objection is sustained.
What is your degree and background, as far as educational background?
I have a Bachelor's of Science degree in special education with a minor in psychology, and I have a Master's of Education in special education with an emphasis in behavior disorders and a secondary emphasis in learning disabilities.
And how long have you been employed in special education services?
I'm in my 32nd year. I also have administrative supervisory endorsements.
Could you turn to opposing counsel's exhibit? Are you familiar with, I'm sorry, I'll ask another question while I'm looking here. Are you familiar with Philippine adoption law?
No.
Well, then if I submitted a document to you from a court or from a psychiatrist or from the statutes of the Philippine law, you wouldn't even recognize that, would you?
No.
You understand the word bias or prejudice? Either one?
Yes.
Let me ask you a hypothetical question, please. Do you know who the Quakers or the Mennonites are, those two groups?
Yes.
If I had an issue and sued a member of that religious group. And there were 12 people in the jury sitting with their religious garb, clothing, etc., that identified them as that religious group. Would you hypothetically surmise that there may be some bias and prejudice there?
I don't know. You could.
Okay, thank you. In a state that has a predominant religion, and that religion requires legalized adoption for certain privileges, for certain rights, would that might be a bias or a prejudice when an adoption and finalization of an adoption is an issue?
Objection, Your Honor, to the relevance of the line of questioning.
Well,
I'm just not
overruled
sure.
on relevance. I can see where it might be relevant. I can see where a path that this might lead may be relevant, but, but let me see if Ms. Yusui has an answer. Do you need the question again?
Yes, I need the question again.
Question, okay, thank you. In a state that has a predominant religion and that religion requires legalized adoption for certain privileges or certain rights, would that might be a bias or prejudice when adoption or finalization of adoption is an issue?
I think that's an assumption. I don't know that I could make the link that direction, but.
Well, adding to the hypothetical, if the judge, the jury, and the prosecutors, or any other officials of that state are part of that religion, could that be a bias?
Objection, relevance.
Finalized adoption, that's the relevance. I'm asking the people who are making the decisions about my children, there it is on the board. There has to be a finalized adoption. Your letters say that. Could there be a prejudice when adoption, finalization, is decided by those individuals?
I'll sustain the objection because I don't hear a tie between the adoption requirement. I mean, adoption is clearly a way of determining parentage, which leads us to residency as well. And I'm frankly, maybe I just don't understand the link because I'm not LDS and I don't understand the inference or the implication that adoption has some special privilege or some special meaning.
Nor am I, for the record.
So the objection is sustained. To the extent it assumes facts that are not in evidence and the relevance issue.
At this point, after we've gone through this particular presentation and questioning, what now would be the definition of a parent in your school district?
Would be someone who has custody, legal custody to make educational, medical decisions, and there is some legal form of documentation that entitles them to do so, whether it be a durable power of attorney or a legal custodial document.
Would it include a parent in the process of adoption?
It may.
What is your understanding of the confidentiality of IDEA?
Objection
Materials.
asked and answered.
That question has been asked and answered. Do you want to narrow it, or?
Yes. You seen the 3rd District lawsuit?
Yes.
Does it name my children's biological names?
Originally, the information was redacted.
I didn't ask you if it was redacted. It was probably redacted because people realized it was illegal. My question basically is, were my children's biological names placed in the original 3rd District Court action?
Yes.
Did that document also reveal that the children were in the process of adoption?
Yes.
In your opinion, professional opinion, did that negate the rights of the parents to tell the children when they're being adopted, or that they were actually adopted children? That was public information, wasn't it?
I don't really understand what you're asking me.
Does a parent have a right to tell their own children about their adoption?
I would assume so.
If it was public, that takes that right away, doesn't it?
Depends on where public is.
Where the public could walk in and see the children were being adopted.
Objection to the line of questioning, Your Honor. I'm not sure that the complaint in this matter has stated a FERPA or any other violation of IDEA confidentiality provisions.
Your Honor, I'd like to rebut that. Counsel has a personal interest in seeing that that lawsuit is not talked about. She redacted the information that I'm quizzing this witness on because she came to the conclusion, evidently, it was either inappropriate, illegal, or she was being kind, perhaps. Hope the camera can get her facial expressions. I think that's important.
Well,
Isn't it true, I'll restate the question, that one of the most sacred things of being a parent and having an adoptive child or children is to reveal to them, at the parent's discretion, that they were adopted?
Same objection, Your Honor. It's not relevant to the issues in this proceeding.
sustained. I understand you're trying to make all of your points and the reasons for your objections and the reasons for your concern with, in your view, a violation of confidentiality laws, but it's just, again, asking this witness about it just isn't the appropriate way to do that.
Well,
I'll let you do it, and part of that is closing, and part of it may be when you're testifying, but the objection is just that this witness isn't, asking this witness that question isn't the way to make that point.
well, Your Honor, under the IDEA law, I have a right not only to question credibility, but also competence. This person released that information. She's already testified to that. It's in the public domain, the names of my children, their addresses in the Philippines and in the United States, that they are being adopted, that I don't live in my house, and there's a lockbox on my door. think that's bearing on competence. This is a person that sat in the meeting that said my kids were not qualified for an evaluation. Is this a competent person? She's already testified that she didn't know the executive order and how it would encompass special education, federal funds. There appears to be some discrepancy whether she understood that there was any kind of an appeal process. We're standing here right now in an appeal process. This is a person that testified that she trains people to give out the procedural safeguards. She didn't give them out.
Objection, this is closing argument.
As to the competence issue, let me give you my view. I mean, since that's your basis for alleging that this is relevant, and see what you have to say. My understanding of the competence provisions of IDEA relate to the assumption or assurance on the part of the regulations and the government that providers of services will be competent. I'm not sure that it's therefore relevant, especially when the issue is relatively straightforward denial of evaluation. I'm not sure it's relevant to attack the competence of the Director of Special Education.
Well, I object. I've already stated that I don't believe that credibility and or competence is maintained here at all.
Well, is there something in IDEA that you can show me that tells me that my recollection and assumption about the relevance of competence is wrong?
There could be, and that is the area that says that the children have a right to be tested with several reliable instruments. It also says basically that the children have a right to competent people overseeing any evaluation or decisions for evaluations. So I think there is a little bit of a stretch of the law that basically here, I think this person's credibility and ability to know the federal regulations and the state regulations are at issue. She sat in the meeting. She's the Director of Special Education. Is she competent, capable, educated, and experienced enough to say, gee, it's residency and it's paternity? She sends an investigator out to my house and discovers a lockbox, reveals confidential information.
Okay.
Okay.
I mean, I've heard your argument, and I appreciate that, but my recollection, without looking it up again, and we can revisit this if you think it's important enough, my recollection, though, is that you were accurate when you said that the children are entitled to service providers who are competent, and that is defined in some ways, and the evaluator needs to be competent, but I don't think it's relevant or appropriate to pursue a line of questioning as to the competence of the Director of Special Education because she was not going to evaluate and because she was not going to provide direct services. What you are attacking her on, if you will, is her
Questioning,
legal.
I would rather have the word questioning.
That's fair. It is her legal conclusions that she drew. And that is the subject of this hearing. And that's why I've allowed you to ask her how she arrived at those conclusions, but I think we've covered that.
With a
couple of
preponderance
times.
of the evidence?
With what, a preponderance of the evidence?
That I've made it clear enough that it appears that I do live in the house, and that paternity under the executive order certainly is met. Under Medi-Cal, it's certainly met. Under the definitions of federal monies, they define who a parent is, not the state of Utah.
And I understand your position on all that, but we haven't even let the district present a response to those issues yet. So once they do that, that's what my decision is going to focus on. And I think, let me also just note, procedurally, I've made notes about, as we've gone through, where I think issues have been raised that we need to focus on later. And so whenever you two think it's appropriate, I mean, I've given you, and I'm not saying inappropriately or unreasonably, but I think I've given you a lot of latitude to go in a lot of places. But at some point, we need to narrow it down, and I've got some questions that I want both of you to address, either in closing or maybe before we excuse all the witnesses, to the extent any of them might be relevant, and we'll cover those whenever we think we want to do it. But it's 11 o'clock now. I think I've, if not explicitly, implicitly promised folks that at about 11 o'clock we'd be done. Is there anything else? Is there anything else that you want to ask Ms. Yusui tonight, or can we wrap up at least the direct examination of her now? Or do you have more for her? I mean, if you do, don't start down the road, because we'll stop, but I'm just looking to see if we can draw a line and say there, direct is done, and we'll come back with cross.
Now, there's one more procedural matter, Your Honor, I'd like to address in the next 3 or 4 minutes, if that would be appropriate.
Okay, so are you done with direct or not? I mean, we'll get to your procedural matter, but I just want to know if we can.
And I think there's further questions that this witness seems to have at least knowledge of.
Okay. So we'll stop with direct testimony tonight, understanding that you're still going on direct examination of Ms. Yusui when we resume, whenever we schedule that in a minute. Now, you have procedural issues.
Yes. We're on the record, right?
Yep.
Your Honor, I've got 11:05 and 25 seconds. I'd like the record to show that I am respectfully